Hello everyone, welcome to Court with Krissy. Happy 4th of July. Before we head to the beach, here's some court fun for you to enjoy before the fireworks. I hope you like it. Court with Krissy is now in session.
So, Ms. Clark, since the last time I've seen you, some things have developed. Mr. Seeger, have you been able to talk with Ms. Clark about those developments and the motion that the prosecutor filed after the sentencing?
I have not, Your Honor.
All right, so I'll just go through them with you, Ms. Clark. If you might recall, I imposed sentence for a probation violation. The probation violation was premised upon you are unsuccessfully being discharged from the drug court program. Do you recall all of that?
Yes.
So at the time that I both took your plea and then sentenced you, I was under the belief that a unsuccessful discharge from the drug court program was what I called a technical probation violation. And so I told you that it was my belief that 15 days was the maximum that you could face. I also told you that because of that, that's what I ended up sentencing you to, the 15 days max. So when I told you of what the potential penalties were, you were under the impression, because I told you that 15 days was the maximum. If you also recall, the prosecutor questioned at the time of sentencing whether or not that was accurate, whether or not it was accurate that it was a 15-day maximum sentence. And so what I told the prosecutor at the time of the sentencing is that that's how I'm treating it now, that he could file a motion asking me to reconsider that if he could provide authority for it. Do you remember all of that?
Yes, I do.
So the difficulty was that the prosecutor then dutifully filed that motion. Mr. Seeger, who was still representing your interest in the sense that he wasn't still representing you formally, but he appeared and made arguments against the motion by the prosecutor. Mr. Seeger was here, Mr. Ziegler was here, I was here on that motion. The motion was titled a motion to correct an invalid sentence. And I heard argument from the attorneys, and then ultimately I made findings. And the findings that I ultimately made were that my sentence that I imposed previously was invalid. It was invalid because some case law and some statutes that the prosecutor referenced convinced me that when I find that there's a violation based upon failure to complete a drug treatment court program, I have to proceed to sentencing on the underlying offense. The underlying offense for you was a possession of methamphetamine, which had a 10-year maximum. Do you remember that?
Yes.
So over Mr. Seeger's strong objection, I made the finding that what I needed to do is find my own sentence invalid and to set this matter for further proceedings. So those further proceedings are what's going on today. What I told Mr. Seeger and Mr. Ziegler that I would do, though, is that I would re-inform you of the maximum. So the maximum for a probation violation, if you're convicted of probation violation for failing out or not successfully completing drug court, is the maximum that you're on probation for, possession of methamphetamine, which is 10 years. Do you now understand that?
Yes.
That's a significant difference than when you entered your plea. And what that means is you have an opportunity to withdraw your plea. I gave you incorrect, as a matter of law, information. And so if you tell me you want to withdraw your plea because I gave you that incorrect legal information, I will absolutely allow you to do that. I'll give you time to talk to Mr. Seeger and decide however it else is you want to proceed. Do you understand? Is that a yes?
Yes.
So basically, I'm going to give you three different options. One is I can set aside some time for you to talk to Mr. Seeger so that you can go through all the different options that you have. Two is I could allow you to withdraw your plea right now if you wanted to withdraw your plea, because again, I gave you incorrect legal advice or representations. Or three, you could choose to reaffirm your plea. If you chose to reaffirm your plea, then I would have the probation agent simply redo a recommended sentence report on the probation violation. I would set it for a new sentencing hearing. The prosecutor would be able to tell me what he's asking me to do. Your attorney would be able to tell me what he's asking me to do, and you would be able to be heard again before I ultimately decided how to proceed with the sentencing hearing. So do you understand those three different options?
Yes.
In between those three options, do you know how you want to proceed?
Yes.
How do you want to proceed?
I'll just reaffirm my plea.
Are you sure that's what you want to do?
Yeah.
And did you want to do that before you've had more substantive discussions with Mr. Seeger, who's here in the courtroom today?
Yeah.
All right. If you reconsider that in any way, Ms. Clark, let me know. Certainly, let me back up a step though. Mr. Seeger, I know that at some point you were not any longer formally on the case because the sentencing order is what terminates your representation, correct?
Yes, sir.
And I know you appeared, you made arguments, and you're here today, obviously, and I appreciate that. To the extent that Ms. Clark does any action, are you willing to reinvestigate whether or not she qualifies for court-appointed counsel?
Your Honor, I would just, because I know that she's currently incarcerated in Otsego County, I would just reaffirm her previous appointment. And
Okay.
just reassign myself.
All right, I'll accept that. Ms. Clark, what that means is Mr. Seeger is officially representing you now, today, and going forward. So did you want a moment to talk with them, or did you want to reaffirm your plea and go through that process?
I guess I'll just reaffirm my plea.
All right, Ms. Clark, you can raise your right hand. You solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth.
I do.
So again, what you told me previously, Ms. Clark, when I misinformed you as a matter of law that the maximum penalty for a technical probation violation was 15 days, what you told me previously is that you were unsuccessfully discharged from the Otsego County Probation, Otsego County Drug Court Program. Do you remember telling me that?
Yes.
Was that true at the time you told me it?
Yes.
And it's still true, obviously, you were unsuccessfully discharged,
Yeah.
correct? And one of your probation conditions in the context of this case was that I ordered you to successfully complete the probation term, correct? Or, I'm sorry,
Yes.
I ordered you to successfully complete the drug court program, correct?
Yes.
But so by unsuccessfully being discharged, you agree that you did not successfully complete it, correct?
Yes.
And we've gone over it before you were under oath, but to be explicitly clear, the maximum penalty, if you're found guilty of violating your probation by not successfully completing probation, not successfully completing the drug court program, is 10 years in the state prison sentence as a maximum. You understand that?
Yes.
And understanding that maximum, did you still wish to reaffirm your plea to the probation violation offense?
Yes.
Do you have any questions at all regarding that in any way?
No.
Then the court will accept your plea, and I find it to be freely, knowingly, and voluntarily given. Counsel, do you believe that there is an adequate factual basis based upon the reaffirmation of the plea?
I do, Your Honor.
Mr. Seeger.
Yes, sir.
Are the attorneys aware of any promises, threats, or inducements that have not been disclosed on the record?
No, Your Honor.
No, sir.
And are either one of the attorneys aware of any, excuse me, yes, are either one of the attorneys aware of promises, threats, or inducements that have not been disclosed on the record?
No, Your Honor.
No, Your Honor.
So, Ms. Clark, I will accept your reaffirmance of your plea. And I apologize because I know that this has wasted a lot of your time and the attorney's time because of my misinformation, but I reaffirm your plea based upon this new changed circumstance and your knowledge of the maximum. So I'm going to have you meet again with the probation staff. They're going to prepare an updated pre-sentence investigative report. Just so that I'm clear, Ms. Clark, are you still expecting to be in Otsego County in about 30 days?
Yes.
All right, so I'll arrange for a writ for you to be here. You have an opportunity to decide how you want to appear. At a felony probation violation sentencing, you have an absolute right to be personally present. Meaning if you ask me to, I'll prepare a writ and have you brought over here to Kalkaska County in person for the sentencing hearing. Totally up to you. If you wanted, I could also agree to have you brought here via Zoom for a sentencing. Again, that's totally up to you. Do you understand?
Yeah.
Do you have a preference on how you appear?
No.
Well, let me ask it this way. Would you prefer to be in person or would you prefer to be via Zoom?
I'll do Zoom.
And all right, and so I'll set it for a Zoom sentencing and we'll arrange for your appearance by a writ. Can you prepare that, Mr. Ziegler?
I will, Your Honor.
Any objection to Zoom sentencing?
No, Your Honor.
Any objection, Mr. Ziegler?
No, Your Honor.
Your Honor, the only thing that I would note, and I'm not sure how the court will construe this, and I am somewhat mindful of what the court had mentioned, and I'm not sure if it was on the record or off the record, Your Honor, but in any event, Your Honor, in terms of credit, I'm not sure what her situation was.
I was going to ask her what that situation is now because I'm definitely going to take into account the time period of delay, which was brought about by the court and not by Ms. Clark. So Ms. Clark, what I mean by that, and I think what your attorney was trying to get to is, are you under sentence right now in Otsego County?
Yes.
All right, so the reason he's bringing this up is I brought it up to both of the attorneys previously. The delay in this case was not through your fault. It was through a misapprehension of law by me. And so I can't give you technical jail credit after you're serving a sentence in another county But the delay from when I originally imposed the sentence on the probation violation up until whenever I sentence you next month, I'm gonna take that into account. Meaning, even though I can't give you legal jail credit because you're in jail on a different offense in Otsego, I can take it into account at sentencing, and I absolutely will. Because it would be unfair for me not to take it into account when the delay had nothing to do with you and everything to do with me. Does that make sense?
Yeah.
Is that what you were asking me to do, Mr. Seeger, is just mindful of that?
Yes.
And I certainly will. Mr. Ziegler, do you have any objection to that procedure?
There you go.
All right, so I'll do that, and I'll ask the probation staff to try to clarify, as well as I'm sure you can, when she started serving her sentence in Otsego County, so that we know specific date of any credit she might get. Ms. Clark, I'm gonna have you meet with probation staff when they reach out to you there in the jail. Then ultimately, I'll set that resentencing hearing in about 30 days. Do you have any questions regarding any of that?
No.
Mr. Seeger, any questions?
Your Honor, the only other statement I would make is, I'm probably making it more complicated than it needs to be, and the court has already indicated that it will take into consideration the time which is spent due to impairment. But theoretically, Your Honor, if any sentence was corrected, it would probably be Otsego, because theoretically, if she had been sentenced in Kilkasky County to whatever time period, that sentence would have run concurrent to her sentence in Otsego. And so it would be my position that she's entitled to all credit up until the time of her sentencing, I guess, going forward, because she would have been sentenced here before she would have been sentenced in Otsego.
Well, I wouldn't interpret it any different if she would be entitled to credit up until she was serving a valid sentence from any other county.
Yeah, yes, Your Honor, but even if she was serving a valid sentence during that time period, it still would have run concurrent. So the time that she's amassed, even though she's under sentence in Otsego, would still, at least in my mind, theoretically still count, because she would have been under sentence had there not been an error of law.
Well, you can certainly brief the issue or be prepared to articulate it later. I'm not going to make a finding on that particular point right now. I certainly will make the finding that she's entitled to credit up until the time she's under a valid sentence in another county, and that whatever time period of delay I will take into account as not the fault of Ms. Clark, and therefore I'm not going to punish her for that. That's the findings I'm making now, and you can articulate in writing or otherwise at sentencing hearing any other changes that you want to bring up.
Thank you.
Any other comment by the people? There you go. Ms. Clark, we'll see you next month for sentencing via Zoom. Thank you.
Good afternoon. Are you Peter Young?
Yes.
Good afternoon, Mr. Young. We're on the record in case numbers 23-9455 SM, 23-9963 SM, and 23-9965 SM. You're appearing for arraignment purposes on bench warrants in each of these cases for failing to appear. You're appearing with Ms. Mistely for the arraignment on the bench warrants. And Ms. Mistely, did you have opportunity to review the allegations on the bench warrants, nature of the same with Mr. Young?
I did, and Mr. Young tells me that he was in the Benson County Jail for 3 months beginning in early April. He was just transported to the Grand Traverse County Jail earlier today from Benson County Jail after he finished his time there.
So he would then be admitting his failure to appear?
Well, the defense is he was incarcerated elsewhere and it was impossible for him to be here, so.
So when the final conference was scheduled on April 17th?
Yes, and he
So
tells,
when were you, go ahead, ma'am, sorry.
he tells me that he was to 3 months in jail in Benzie in early April, and he just was transported to Grand Traverse this morning from Benzie after serving the 3 months. So the dates would seem to align with what he's telling me.
Not April. Would be late April, June, and then the beginning of July, right? In any event, okay, but Mr. Young, did you let your attorney know that you were in the Benzie County Jail?
No, I thought that you guys knew.
Well, you knew that you had Mr. Travis. You had appeared with Mr. Travis, right? And so you knew that you had him as your attorney. Did you contact Mr. Travis?
No, I thought that you guys knew. I thought you guys knew that I was
Okay.
in Benzie.
Okay, well, short of us being able then to verify the exact dates that you were incarcerated, and not having the information that you were or were not in contact with your attorney, if you are going to request a hearing in this case, you can do that, or if you are going to admit that you failed to appear, I will get the file to Judge Cooney, and he would be able then to accept your plea. And I'm not certain that that would be today. He's in Antrim County today.
Could I get another PR bond so I could talk to my lawyer?
You can talk to your attorney there in the jail.
I know.
But Mr. Young, your history, follows you, and your failure to appear rate is right up there amongst the worst. I believe it's probably because we don't have mailing addresses that are good for you. So I understand those reasons. However, the court is well aware of your failure to appear history. So if you are going to admit the violations, you're going to waive your right to a hearing. Do you understand that?
Okay, is there any chance that I could get out today?
No, sir.
Okay, when do I talk? When do I get to talk with the judge?
As soon as he's available, and that may be on Friday.
Is there any way I could please get a PR bond, please?
No, sir. So do you understand, if you are going to admit the violation, that you'll waive your right to a hearing in this case? At that hearing, you'd have the right to have Mr. Travis represent you. You would also waive that right as well. Mr. Travis is still your attorney and will certainly represent you in the underlying cases. But you understand you're not going to have a hearing if you choose to admit the violations.
They're misdemeanors, right?
Yes.
I've been locked up for 3 months.
Do you wish to have a hearing in this case?
No, I'll take them. Hopefully, do you think that I'll be able to get out by Friday?
Okay, so we will get the file to the judge. Again, I don't know when exactly he will be able to see you, and that would be in all three of those case numbers. But we will get those files to Judge Cooney, and for right now, then you are remanded to jail until the time that you are able to speak with the judge.
Do you think that I'll see him on Friday?
You will not see Ms. Mistily.
No, yeah,
You will
will I
be
see
seeing Judge Cooney.
on Friday?
Yes. Is he on?
That is likely, but I would urge you to call Mr. Travis today. And you can call him for free. Do you have his number?
I lost my voice. I can't talk.
Well, you can
Okay, thank you, Mr. Young. You are all set.
call your attorney.
Let's first talk to Theodore James Williams. Mr. Williams, would you come right up to the podium? And I don't think they give an advice of rights to the pretrial people. This isn't in my queue, so give me a minute to find it. Moving kind of slow this morning.
I know that feeling.
I'm gonna have to find each one of these separately. This is an old case, 221581. People versus Theodore James Williams. Mr. Williams is charged with contributing to the delinquency of a minor and furnishing alcohol to a minor. This is alleged to have occurred 2 years ago in July of 2022. Let's take a look at this. Warrant alleges that on or about July 18th of 2022, you did allow someone under 17, a minor, to consume alcoholic beverages. And they're going to dismiss furnishing alcohol to a minor. That one carries up to 60 days in jail and a fine of up to $1,000. This is just a plain old 90-day, $100 misdemeanor. It's pretty drunk. Let me see why this is 2 years old. He got arrested in 2022. No, he didn't get arrested until June of 24. You did call about the warrant and we gave you information about it, then you never showed up. And then somehow within the last month or so, you got arrested. How did you come to get arrested on this 2-year-old warrant?
My girlfriend and I got rear-ended in Kalamazoo, and I had a warrant out in Van Buren as well for child support.
All right, how long were you in jail?
Just a couple of days. It was the day before Juneteenth that I got picked up.
So did you spend time in Van Buren? Did you start in Kalamazoo?
No, it was a portage officer. We just met a Van Buren officer in
So you went to jail in Pawpaw and then you came to jail in Centerville?
Yeah.
How long were you in Pawpaw?
About a night and a half.
And how long in Centerville?
Just a few hours.
All right, we'll call that 2 days. All right. Prosecutor indicates they're going to dismiss count 2, furnishing alcohol to a minor, for a plea to count 1, contributing to the delinquency of a minor. Apparently, you and your son were drinking together, got in a fight, and somebody called the police, and he was a .15, and your daughter, or some 14-year-old girl, was also drinking.
Yeah.
So this was not good all the way around.
No.
All right. Do you understand that if you plead to that charge, you'll be giving up your right to have a trial in front of a judge or jury?
Yes.
If you had a trial, you'd have the right to be represented by an attorney. All you got to do is ask me. I could appoint an attorney for you. You could hire one of your own choosing. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify in your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, somebody set off the alarm. Which I've been known to do, but I have an alibi this time. I'm in here. And if you did not wish to testify, the judge or jury cannot hold your silence against you, and you have the right to be presumed innocent. unless they were able to prove your guilt beyond a reasonable doubt. Do you understand?
Yes.
All right, what was all this about? Now, you live on Michigan Street, which is different than Michigan Avenue or the rural Michigan Avenue. This is Michigan Street over in Second Ward?
Yeah, right. Just down from Dad's place.
Yes. All right, well, what was going on here last July of 2022 when you were drinking with your kids?
My son just got stupid and decided he wanted to try and fight me. And I told him it wasn't going to end well for him. He was either going to leave in handcuffs or an ambulance. I didn't fight him.
Well, what was he drinking?
A little bit of everything. We were doing shots.
Oh boy, this was after midnight.
Yeah.
I know a man, he says two things. Nothing good happens after midnight and nothing good happens after shots. So this is an example of both. Were you out in the yard?
We went around the block and he continuously tried to fight me. So
Where is everybody now?
he's living in Kalamazoo. He's 20 now.
And you still live at that address?
Yes.
Now, you knew there was a warrant. You were just trying to stay under the radar. But you also had a 14-year-old girl drinking alcohol too.
Yeah.
Just a bad plan. Was the child's mother there also
Yeah. You actually saw her a few weeks ago.
on the same thing?
Yeah, she was told that the cops said that I put all the blame on her, and I actually told them that it was all me that night.
I guess I don't remember the details, but I'm gonna give you 2 days in jail. Credit 2 days. This is 2 years old. There's a $100 fine and $125 worth of costs. Total is $225. Can you pay that today or do you need time to pay it?
I need some time to pay that if I
Can you
can.
pay it in 30 days?
Yeah, that shouldn't be an issue.
Well, apparently you haven't been in any trouble in 2 years, but this wasn't a real good plan.
I try to stay out of trouble.
Well, this was a recipe for disaster. He was 2 times the legal limit and he's 18 years old, probably weighs 150 pounds.
He's a big boy. He's ranking right up there with me now. So,
Well, I'm gonna make this due by August 2nd. All right, you're good to go, sir.
thank you.
Take care.
All right, welcome from Wexford County. Is that Mr. Cronin?
Yes, sir.
Okay, I'm just hitting the buttons asking you to start your video, and thank you for doing that. So we are on the record now in the matter of People versus Kyle Richard Cronin. This is file 24-4931FC.
Ryan Ziegler on behalf of the people, Your Honor.
Thank you. And Mr. Cronin, is it accurate that you are planning to and asking the court to allow you to represent yourself in this matter?
Yes, Your Honor.
All right. So there's a lot of things that the law requires I go over with you. Some of those things I'm going to go over as some general background procedure matters. I'm not in any way attempting to provide legal advice to you. I can't do that. But because of the way things have come up, I need to address them with you. That is, I received what was titled or listed as a request for dismissal of a judgment without prejudice made by motion. So in terms of motion practice, I just need to let you know what you need to do if you have a motion in the future that's going to be considered by the court. What you have to do is you have to arrange to call my staff. My staff's name is Chris, to set time aside on my docket. So today I have time on my docket. I'm going to ultimately respond to the motion and rule on it. But so what you'll do is have to call her. I'll give you the phone number. Her name is Chris, and she's my scheduling clerk. So if you have a motion, you have to ask her for time to set it aside on the docket. Then I know I have time to be able to address it. And then you have to file what's called a notice of hearing. That notice of hearing puts the prosecutor on notice that there's going to be a hearing, and it makes sure that I have it on my docket. then I can address it. And the second thing is make sure when you do so, that you're sending copies to my staff. And when you do, you send any copy of anything to the prosecutor's office. In other words, the rules of court require that when you send anything to me, it's also got to be sent to the prosecutor because he's the other party in the case. So Mr. Ziegler, do you have the address that he could send things to you?
Yes, Your Honor, it's 605 North Birch Street, Kalkaska.
Your Honor,
Yeah.
if I may speak briefly, I did ask or request that copies of this, the motion that I filed be sent to your office as well as the prosecuting attorney and the county clerk's office. So that
Okay, and you might have done it just right. I didn't know that. And so if you did already, that's perfect. But you need to make sure and do it yourself. You can't just send it to the clerk asking them to transmit it. You've got to send those. You're the one representing yourself, and so you've got to do that.
Your Honor, being housed in Wexford County, the only thing that I can send is postcards. I'm not allowed to actually file any documentation in an envelope.
Well, that's going to be problematic for you then. And that's one of the issues that is why oftentimes defendants in your position decide to not represent themselves, because there's the legal right to represent yourself. And I'll go through all of those warnings in a moment, but there's the practical implications as well, because the court rules require a certain action. And if you're telling me that Wexford County won't let you send anything except a postcard, that might be hard for you to comply with the otherwise required court rules.
Absolutely, Your Honor.
So I can't waive the court rules. I can't waive the court rules. I can just tell you again, the way that the law reads, what you have to do. One of the other things that's required though, Mr. Cronin, is I have to go through the maximum penalties of every offense that you're charged. I'm assuming you know those things. But the law requires when you ask to represent yourself that I go through those, and I have to go through general things every time we have a hearing. So pay attention, please. I know you probably already know these things. The offense you're charged with in count 1 is known as assault with intent to murder. That offense is a felony. The maximum punishment for that felony offense is up to life in prison or any number of years. Do you understand that?
Yes, Your Honor. I also noticed that you're also supposed to include the minimum sentence in this.
I am. Any mandatory minimum. So
Absolutely.
If you can let me go through it, I'll go through it. So
Yes,
the law
sir.
requires that I tell you what the maximum sentence is for each offense and any mandatory minimum. Then I have to go through some other questions with you. So the maximum for assault with intent to murder is life or any number of years. There's no mandatory minimum for that offense. Count 2, weapons, firearms, possession by a prohibited person is a felony offense with a maximum potential punishment of 5 years in the state prison system and or a fine of $5,000. There's mandatory forfeiture of the weapon or device for that offense. With the assault with intent to murder charge, moving backwards in count 1, if you're convicted of that offense, it's required that DNA is taken upon your arrest, and a consecutive sentence can be imposed under a statute 750.506A if the assault was committed in a place of confinement. Count 3 charges you with the offense known as assault with a dangerous weapon, otherwise known as felonious assault. That is a felony offense with a maximum punishment of 4 years in the state prison system and or a fine of up to $2,000. Again, the requirement is that DNA must be taken upon your arrest. And again, a consecutive sentence can be imposed under 750.506A if the assault was committed in a place of confinement. Count 4 is weapons, felony firearm. That is a felony offense. That offense has a mandatory minimum 2-year prison sentence. So it's a 2-year consecutive sentence with and preceding, meaning served before any term of imprisonment imposed for any other felony or attempted felony conviction. Further, there's mandatory forfeiture of any weapon or device. So that count 4, again, to be clear, has mandatory consecutive sentencing, and it's a mandatory 2-year penalty, a mandatory minimum 2-year penalty. Count 5 is weapons, firearms, possession of a loaded firearm in or upon a vehicle. That offense is what we call a high court misdemeanor, otherwise known as a felony, because the maximum punishment is up to 2 years in the state prison system and or a fine of up to $2,500. If you're convicted of that offense, there's mandatory forfeiture of a weapon or a device. You're also charged in this case as a habitual offender second offense notice. The effect of the habitual offender second offense notice is that each of those maximum penalties that I've indicated is raised in a factor of 1.5. In other words, the weapons felony firearm would still be a 2-year consecutive sentence, but the weapons possession of a loaded firearm would be a maximum of 3 years. The assault with a dangerous weapon would be a maximum of 6 years. The weapons, firearms, possession by a prohibited person would be 7.5 years maximum, and the assault with intent to murder charge would remain the same because it's already a life maximum. So do you understand the maximum penalties and the effect of the habitual second?
I do, Your Honor.
Do you understand the mandatory minimum associated with the weapons, felony, firearm?
Yes, Your Honor.
So because of those maximum penalties and the mandatory minimum penalty with the one offense, there's significant risk to you. There's significant danger to you. One of those risks is that Mr. Ziegler is a trained attorney. He's been a prosecutor in this community for a long time, and he's handled dozens, if not hundreds, of criminal jury trials. So he well understands the rules of law. He understands the rules of procedure. He understands the court rules and the Michigan rules of evidence. I'm assuming you don't have any formalized legal training. Is that accurate?
That is accurate, Your Honor.
So because you don't have that formal legalized training and experience, and because the prosecutor does, if you represent yourself, you're going to likely be at a significant disadvantage. You understand that?
Your Honor, I do understand that.
And while I'm going to do everything I can to make sure that you receive a fair trial, even despite my efforts, you still might not receive as fair of a trial as you would if you had an attorney, because you don't perhaps understand the way that the rules of evidence apply, or the way that the court rules apply, or the general rules of procedure. Do you understand that?
I do understand that, Your Honor.
So in other words, the risk is significant. Are you clearly aware of the risks that are involved with self-representation?
Yes, Your Honor.
Are you knowingly making the choice and the request of the court to allow you to represent yourself?
Yes, Your Honor.
Do you think you're going to be able to apply the rules of evidence in a way that benefits you?
Yes, Your Honor.
Are you making this request with both eyes open?
Yes, Your Honor.
Do you fully understand the consequences for any of the offenses if you're convicted of them?
Yes, Your Honor.
Do you have any questions about any of that?
No, Your Honor.
If at any time, Mr. Cronin, you decide that you want to consult with an attorney, immediately stop me, even interrupt me. And if you want to consult with an attorney, I'll make one available. If you want to ask that attorney if you qualify for court-appointed attorney assistance, you can do that. And if you qualify, one would be appointed for you. Do you understand all of that?
Yes, Your Honor.
Okay, again, are you sure that you want to represent yourself?
Yes, Your Honor.
All right, so I'm going to take up first your motion that you had filed, and then we're going to take up what I refer to as a status conference. I'll repeat again, though, Mr. Cronin, a lot of these things, when we have future hearings, if we have future hearings, are repetitive. So bear with me. I have to go over the advice of rights regarding your self-representation at the conclusion, at the start of every single hearing. So it's going to be repetitive, but it is legally required. So, Mr. Cronin, I know. All right, and I note that I've received your motion. I note, Mr. Ziegler, I did not receive a written response to the motion. Did you file a written response?
I did not, Your Honor, primarily because it was not noticed for hearing at any point, and I have, I believe under court rule, 5 or 7 days in advance of the hearing date to file a written response.
All right.
Your Honor.
Well, hang on just a minute, Mr. Cronin. I'll note that for the record, Mr. Ziegler, and I'll cover it later in a different way and allow you to be heard and make a full record. Mr. Cronin, I don't mind that you're asking to be heard again, though. Remember that in the courtroom, there's always a format and a procedure to everything. That can also be slightly confusing or even annoying, but that's the way it goes. So did you wish to be heard before I addressed your motion?
Yes, Your Honor.
What did you want to have me hear?
Your Honor, may I speak briefly on the motion? I had Sergeant Tilly forward to your office.
I'm sorry?
I said, may I speak briefly on the motion? I had Sergeant Tilly forward to your office.
No, because what the court rules provide is discretion to the court. And so MCR 2.119E3 provides the court with discretion to either dispense with or not allow oral argument when I'm convinced that I'm not in need of oral argument. And so attorneys often ask, and so do litigants, to provide oral argument in supplementation of whatever's filed in writing, but the court rules plainly provide me discretion. In this case, I exercise my discretion to dispense with oral argument. So let me assure you, Mr. Cronin, I've read every single word that you've offered. I understand the nature of your motion. I understand what you're asking me to do, and it's been made clear in your motion. You're very articulate in what you're asking me to do, which is dismiss or issue a judgment without prejudice. Your reasoning for doing so is stated within your motion. You claim that there's absence of credible evidence corroborating and contradicting the testimony of statements by the witnesses of these alleged allegations. And you go through in relatively clear and at least credible to the court in the sense that I believe you're being clear I haven't compared police reports, of course, I don't have those, but it appears that you're trying to credibly repeat all of the things from the police reports in terms of what you see as evidence of contradictory statements between any of the reporting or complaining witnesses. Your statements within the motion are also reflective of Michigan law. And that is, your claim is that it's axiomatic that the credibility of a witness is an issue of the utmost importance in every case. It's also axiomatic that evidence of a witness bias or interest in a case is highly relevant to his credibility. Those points of Michigan law are clear. You've accurately stated them and repeated them. However, what you're asking me to do is to compare the credibility of witnesses in a pretrial motion. The inability of the court to do so is well noted within Michigan Supreme Court and Michigan Court of Appeals cases. That is, I, as a trial judge in this case, am not sitting as a finder of fact. I am determining issues of law. Issues of credibility, that is, whether a witness is going to be believed later, are always issues of fact. Issues of fact are solely determined by the fact finder, which, unless and until there's a waiver of a jury trial, the fact finder is the jury. So even if I found that your arguments were convincing, they could not convince me to dismiss the case, because ultimately factual questions are resolved by a jury, not by a judge. Judge, I resolve issues of law. For example, whether or not there was enough information to be able to charge you, or whether there was a legal stop, or whether or not the police engaged in misconduct. Issues of law can be determined by the court in a pretrial motion. Issues of fact, however, cannot. Again, because credibility issues must always be resolved by the jury. In a separate communication, I recall you wrote down that you were demanding trial by jury. I was assuming that was the case. I always assume until I'm told otherwise that all criminal defendants ask for a jury trial because that's the constitutional right. So because you're making arguments about credibility, the motion necessarily must be denied at this point because the jury has to determine those issues. Mr. Ziegler, because I'm ruling in that fashion, I'm denying the motion, I'm going to ask you to prepare an order which just simply says the defendant's request for dismissal or of a judgment without prejudice is denied for the reasons stated on the record. Can you prepare that order?
Yes, Your Honor.
And I recognize that you made the request to be able to respond in writing. Given the court's ruling, did you still wish an opportunity to address a response in writing?
No, Your Honor.
All right. Did you wish to make any other sort of statement for purpose of appellate review on the court's exercise of discretion or the ruling itself?
No, Your Honor.
So, Mr. Cronin, now I'll give you an opportunity to make a statement for purposes of appellate review. I do that often for attorneys, and I'll do that for you. What that means is, if you wanted to state something for the record to preserve it for the Court of Appeals regarding my ruling or my exercise of discretion to dispense with oral argument, you can do so now.
Okay, thank you, Your Honor. Your Honor, the foundation of these charges are solely based around witness credibility, and one other crucial factor which undoubtedly plays a vital role in pursuing these charges is the alleged firearm said to be used. Your Honor, I didn't include this piece of information in my motion primarily because the motion contained facts that could prove to be insufficient with the support of documentation, whereas the alleged firearm, I could not. Your Honor, my point in all of this, that this case and these charges and the supplementary incident reports lack any real burden of proof and therefore does not carry any solidity to even continue on in the courts, and therefore should be moved for dismissal with or without prejudice. Thank you, Your Honor.
Thank you, Mr. Cronin. I accept your statement for purpose of appellate review. But again, for the reasons I've already indicated, that motion is denied. I'm just going to repeat again, though, Mr. Cronin, you've heard the prosecutor's objection to the motion procedure. In other words, what he was claiming, and he's right, is that he has a right under the court rules to respond to any motion. I didn't give him the right to respond today. He's not asking to respond now based upon the ruling that I made. But in the future, you need to be aware, if you file a motion that doesn't provide the time periods under the court rules, I'm going to have to either delay or dismiss that motion because those are required. The prosecutor is entitled to be able to respond to any motion that you file. I also need to back up a step, Mr. Cronin. I know that we went over all the information, but I know that you were asking me to allow you to waive counsel, and I didn't make a couple of required findings. But based upon your conversation with me, it's clear that your decision to waive counsel and represent yourself has been made knowing, voluntary, and accurate. Also, throughout the time period you've been in here today, Mr. Cronin, it's clear to me that you are being respectful. You're not proving to be problematic, and that's an important thing for me to find as a matter of law. In fact, at least right now, is that under the People versus Anderson waiver procedure, I have to make a determination that you would not be unduly disruptive or problematic for the court. If I made the finding in the future, for example, that you're unduly disruptive or that you interfered with the court's ability to process its docket, those are factors that the court consider in denying a waiver of attorney. But I don't make those findings at all now. You've appeared respectful. It appears that you're trying your level best to do what you need to represent yourself. So I accept your waiver of counsel, but at any time, if you decide otherwise, that you want to have counsel, you let me know and I'll have you reconsider that. Do you understand?
Thank you, Your Honor.
So the other way that we need to proceed today, Mr. Cronin, is by what I call a status conference. Ordinarily, a status conference is for me to get an update from you about how you want to proceed. In the context of a criminal case, that's ordinarily, do you want time to talk with the prosecutor about a potential way to resolve this case, or do you want me to simply calendar the case for trial?
I would like to talk to the prosecutor about wager in this case.
All right, and so I'm going to give you that opportunity. I'm going to also hear from the prosecutor, but here's the difficulty again. You're representing yourself and you're housed there in Wexford County. The practical problem or difficulty with that is just a way of communication. I'm not saying there's not a way around it. There might be an easy way around it, but that's the potential practical implication. You also need to be aware that while the statements that you make in the context of plea negotiations can never come in, what you say to the prosecutor might affect how he decides to proceed with any plea offer that he would make. So be aware of those things. It's all something that you should be taking into account. Mr. Ziegler, did you wish to be heard on Mr. Cronin's request to talk with you about plea discussions?
Your Honor, I did have an opportunity to speak to Mr. Cronin prior to the preliminary exam. We handled that via Zoom, and Wexford Jail was able to accommodate us that way.
Okay.
So I don't have an issue trying to arrange another Zoom meeting and discussing potential resolutions with Mr. Cronin.
Is that what you were asking, is to have it take place via Zoom, Mr. Cronin?
Yes, Your Honor.
And are you just going to simply try to set that up with the jail to have a time period to set aside?
I'll contact the jail and find a time that works for both of our schedules, Your Honor.
So, Mr. Cronin, what I would likely do if you ask me to is adjourn for whatever time period you think is necessary to give you time to meet with the prosecutor. Is that what you want me to do before I take any other formal action on this case?
Yes, Your Honor.
Okay. And are you anticipating, Mr. Cronin, filing any additional motions, or don't you know yet?
I do intend on filing additional motions, Your Honor.
Do you know yet what types of motions you're planning on filing?
What is the fact motion that you were trying to form me on earlier?
What was the what motion?
The motion for dismissal. You said there's two different types of motions for dismissal.
So the types of motions that I could consider would be, for example, if you filed a motion that challenged an issue of law, a legal determination about whether or not there could be charges or there should be charges. There are times when the court can make determinations in advance of trial on issues of law. Generally speaking, and almost exclusively, issues of fact, though, have to go to the fact finder, to the jury.
Okay.
So for example, if challenging a matter of law, you might be able to have me issue a pretrial ruling regarding it.
That is the motion that I plan to file then. Is the challenge.
How long do you think you need to file that or any other motions?
Just give me maybe 1 or 2 days, Your Honor.
Oh, I was going to give you a lot more time than that because these are extremely serious charges. I don't want to rush you, Mr. Cronin, and I'm certainly not going to ask to rush the prosecutor either. On the other hand, if you know that you'll have them done within that time period, that's fine.
Yes, Your Honor.
All right. So what I ordinarily do and what I'm going to do in this case, Mr. Cronin, is file a motion cutoff. And that is, I want you to file the motions that you think need to be heard by me, and then I'll hear them as long as they're timely filed and correctly filed into the court rules. I'm going to give the prosecutor the same opportunity to file whatever motions he thinks I should consider and decide before trial. But after the time deadline that I set, I'm not going to consider any other motions. I'm going to consider them time barred because ultimately, I want to get this case scheduled for trial if we need a trial or resolve the case in a different way if we can do that. So if I provide a total of 30 days for you to file any motions that you need, is that enough time then?
Yes, Your Honor. Thank you.
Mr. Ziegler, if I give you that same 30 days to file any motion and or notice under court rule or statute, is that enough time?
Yes, Your Honor, only insofar as if the defendant's motions raise additional issues that I feel compelled to file something, I might need additional time to do that, but I don't expect that to be the case.
Well, and so here's what my ruling is gonna be, is that I'm gonna provide a deadline of 30 days for each the defendant and the prosecutor to file any motion and or any notice under court order or statute. In this particular case, what I'm gonna require, Mr. Ziegler, is if you file a motion, a notice under court order or statute, I'm gonna require that you notice it up for a hearing where I can make a determination on the merits. And Mr. I'm sorry, I blanked on your name for a minute, Mr. Cronin. Mr. Cronin, again, make sure and follow the procedures of serving the prosecutor with a copy of the motion, as well as obviously get the original filed with the clerk and then get a copy to my staff. Again, the deadline for the filing of all motions is 30 days or there will be time barred. Then I'll set a status conference next month. That'll be in about 30 days. That should give you time not only to get those motions filed, to get a hearing date from my staff, also hopefully to have those discussions with Mr. Travis, with Mr. Ziegler, I'm sorry, if you want to have those discussions about potentially ways to resolve the case. Does all that make sense, Mr.?
Absolutely. Thank you, Your Honor.
Does all that make sense, Mr. Ziegler?
Yes, Your Honor.
Anything else you would want me to cover at this point?
No, Your Honor.
Anything else you would want me to cover at this point, Mr. Cronin?
No, Your Honor.
Okay, we'll see you in about 30 days via Zoom again next month. Good luck until then.
Thank you. You as well.
Say your name. Patrick Johnson. You have a lot of traffic matters they gotta get through. All right, you got about 30 or so, I don't know, I lost count. Traffic matters which you failed to appear in court for. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside these arrest warrants, give you a personal bond in each of these misdemeanor matters, and carries a maximum penalty of up to 90 days in jail and or a $500 fine. You have the right to remain silent. Anything you say can and will be used against you. You have a right to an attorney. If you can't afford an attorney, one will be appointed on your behalf. Is that clear? Say it loudly. Yes, yes, sir. All right. Be patient. These are a lot of tickets. Ticket U33889516. Violation of city marijuana code. Ticket U37686217. Violation of city marijuana code. Ticket 195247531. No operator's license on person. Ticket 193990081, 82, and 83. No operator's license on person. Driving unregistered motor vehicle. No insurance misdemeanor. Ticket 207112601, 02, and 03. Driver's license never required. Driving unregistered motor vehicle, no insurance misdemeanor. Ticket 204605950. Strike that. Ticket 204605951. Violation of city marijuana code. Ticket 214157451 and 52. Driver license not valid. Improper plates. Ticket P969542. Driver license never required, no insurance misdemeanor. Ticket P1016091. Driving unlicensed, no insurance misdemeanor. Driving unregistered motor vehicle. Ticket X360165. No operator's license on person. Ticket X3605892. No operator's license on person. No unregistered motor vehicle. No insurance. Ticket P1033087. No insurance misdemeanor. Driving a registered motor vehicle. Failed to display a valid license. Ticket P1034039. No insurance misdemeanor. Driving license not valid. Driving a registered motor vehicle. Ticket P1034188. Improper plates. Ticket X3730870. No operator's license. Ticket P1099627. Improper place. No insurance misdemeanor. Driving a registered motor vehicle. Ticket P1100287. Driver's license never required. Ticket P1103178. Failed to display valid operator's license. No insurance misdemeanor. Driving a registered motor vehicle. Ticket P1118927, no insurance misdemeanor, driver license not valid. Ticket P1119152, failed display of valid operator's license. Ticket P1184299, improper plate, driving arrested motor vehicle, driver license suspended. Ticket P1338436, no insurance misdemeanor, driver license not valid. Ticket P1341100, driver license suspended. Ticket P1344622, driver license suspended. Ticket X4033583, no operator's license on person. Ticket P1336528, improper plates, no insurance misdemeanor, driver license suspended. And last but not least, ticket P1347594, no insurance misdemeanor, driver license not valid. Boy. All right, Mr. Williams, on each of these misdemeanor matters, you have a pretrial July 30th in front of Judge Larry Williams. Is that clear?
Yes.
Now to your main matter. Calling case number 24057940101. Please say Michigan versus Patrick Johnson. Appearances, please.
Thanks, Magistrate. Steve Vincent for the people.
And Ryan Marat, P83665, on behalf of Mr. Patrick Johnson. We waive the formal reading. Mr. Johnson stands mute. He's been advised of his rights.
Court, I'm not guilty plea on behalf of Mr. Johnson. Bond recommendation, Mr. Vincent.
Judge, we're going to be asking for $20,000 cash. We're also going to be asking for a tether as well as house arrest. This defendant right now is out on 2 different cash bonds regarding 2 different matters that are over in Frank Murphy. One of those matters has to do with the fleeing from police, where this defendant allegedly rammed a police officer, the vehicle, 3 times before he ended up taking off on the roadway in excess of over 100 miles an hour. Took those officers on a 46+ minute chase, putting lives of many in the city at risk, driving recklessly. He was charged with the fleeing, magistrate, as well as the driving recklessly. But ironically, the day before, he ended up fleeing from police as well. So he was charged in that matter. He was charged in the subsequent matter. He was given cash bonds on both of those cases. I believe 5,000, 10% on one and 5,000 cash assurity on another. He posted on both of those. And while he was on cash bond for both of those cases, he's found, as you saw, magistrate, in this incident with a loaded firearm underneath the seat in a vehicle.
So, Mr. Vincent, I get that. My question is, so he's required to have a cash bond under the statute?
I don't think so, magistrate. I think the statute, the 7656A, the requirement would be if he had a personal bond. This, I just thought it was worth mentioning to you because he had posted cash bonds on the other 2. And while he was under all of those conditions, he ends up picking up this
one. Okay. Anything else you want to add, Mr. Vincent?
We have that admission as well here to that firearm that was loaded and stolen, and that's being charged as an FF. So it's a straight 2. So he's got a lot going on for him, Judge. We find him to be a danger. So respectfully, we're asking for that cash with house arrest.
Mr. Rod, is your client working?
Yes, Judge, he is. He owns he's a tow truck driver. He owns Fast Lane Towing.
He's a what?
He owns a tow truck company. I'm sorry. My notes indicate that he owns a tow truck company, that he owns Fast Lane Towing, Independent Roadside Assistance.
He doesn't have a valid license.
Yeah.
Right. My notes indicate that he's the owner of that business. I know I started by saying he's a tow truck driver, but I did look at my notes and it indicates that he owns the company.
He owns a tow truck company, but does not have a valid license.
Judge, I can't speak to his license or not. I don't have that information.
No, I know you can't. And I did not intend for you to answer that. I'm just saying it's just quite ironic.
Okay. Would the court like me to address bond, Your Honor?
Yes.
Okay, so Mr. Johnson's 28 years old, Judge. He's a life resident here in the state of Michigan. He is, has a local address here in the city of Detroit. He has a stable residence with his son, who he has full custody over. Your Honor, I'd like to just advise that with this investigator's report for this case that he's being arraigned on today, there's no allegation that he was evading police officers, combative with police officers. It indicates that there was a search incident to arrest for no insurance with 2 people in the vehicle. There's nothing that's, I know that he does have that matter pending that Mr. Vincent referenced, but with regard to this, the report even says they were asked to exit the vehicle, both occupants complied. There was nothing in that nature with this charge. So he's dealing with those bonds in those cases. I'd ask the court for a personal bond here. Obviously, I don't believe that there's any previous history on those matters because I think it would have been mentioned, but seems that he's showing up to court. I don't see a reason for a cash bond or a tether since he's showing up. I'd ask the court for personal bond here.
Well, it's interesting that Mr. Johnson doesn't have a license, and this incident occurred. He's driving 95 miles per hour in a 55-mile-per-hour zone.
He was a passenger.
He was a passenger, or he was not the driver?
No, he was the driver in the 2 previous incidents that took place.
But not this one.
Right. Those 2, the reason why there isn't any habeas is because, well, 1, he was on cash for a while and then he posted, but 2, he was just arraigned in late April.
Okay. Okay, I got it. And just for point of clarification, no habeas history on those other matters?
No, that's what, and I'm sorry, Magistrate, maybe I wasn't clear. He was arraigned on both of those April 29th. So he was given cash. It took time for him to post on both of those. He was just bound over. Just had a motion hearing June 10th on both of them. Trial dates in respectively August and September. The heart of this goes to the idea that while he's on bond in 2 different matters, that he's possessing a loaded firearm that he admits to. And that's where the people see the danger. With the drugs.
Okay, this is what I want to do. $50,000 on a personal bond while his case is pending. You're not to possess any handguns, firearms, other dangerous weapons. You're not to, no drugs. You're fitted with a GPS tether. 9 p.m. to 6 a.m. curfew.
Already on house arrest tether. That's what I understand.
You are?
Yes, I have tether on my leg. Right? I'm already on house arrest. I can't even talk now. From my previous case, they put me on tether.
Hey, Mr. Johnson. There's no need for you to make any statements.
No, I'll continue it. GPS tether, house arrest.
And Judge, and let me just explain this to you. So this incident took place May 11th. Those incidents took place in late April. Initially, he was just given a cash bond that he ended up posting when he got bound over to circuit court. Then the circuit court judge, I believe it was June 10th, after this incident took place, he was given tethers on both of those. So there's a lot to it. They saw that he needed to have a tether on top of the cash.
He's got a 3rd tether order on him, $50,000 personal bond.
All right.
July 5th, probable cause, preliminary examination, July 12th, both in front of Judge Jefferson. Have a good day.
All right. Thank you.
Thank you.